Well, still in studio, Professor George Wajakoya and Speaker of Nyeri County Assembly, that is Honorable John Kagusha. We're expecting to get a hold of Honorable Farah Malim, but it appears that his network, I don't know whether he's in Garissa or where, is not as friendly. But all the same, the conversation goes on as we talk the politics of the day. And this, as leaders, or generally the country at large, is flexing muscles towards 2022. Just getting to understand what is likely to culminate. A majority of people having waited to hear the verdict of the BBI, that is at the appellate court, and evidently it was not all rosy. But does reggae proceed or not? I mean, these proponents are coming to a point of acknowledgement that they can as well still get to realize that some of the proposals or the clauses that had been enshrined in the BBI to life. That is after, they exhaust other options. The biggest question then would have been, why wouldn't they have taken these options from the word go? If we are to go to Parliament, it is something that had been proposed right from the word go. Why was it so hard for them to take that direction? And as at now, Right Honorable Raila Odinga declaring that he would not be interested in proceeding to Supreme Court to challenge the ruling or the judgment of the Court of Appeal. But as it is, Attorney General is out here, says that it is time that he challenges this as he looks at three key important things: applicability of the structure or the basic structure doctrine, the popular initiative threshold, and the presidential immunity. This in defense of his boss. But the question then would be, Professor, I mean, the Attorney General has hugely been faulted for having misled the President on numerous occasions, having not executed his mandate as expected. Of what importance will it be if he were to decide to take this direction of challenging the Court of Appeal's decision at the Supreme Court?
First of all, if this Attorney General was in the US or UK, you should have resigned voluntarily.
Okay.
Failure to which you should have been impeached because of misleading the President. And I have no kind words for the Attorney General, because he's the one who has let President Uhuru down as the chief government advisor. Next time, whoever becomes the president should actually be very keen on who the Attorney General is going to be. Now, when it comes to issues of basic structure, doctrine, this is a principle that has been developed for many, many years by the Indian courts, and it actually precedes the Indian independence when India was under the British colonial rule. And if you look at the countries that have adopted the basic structure doctrine, countries like I mentioned before, Uganda being on the list, Kenya being another country, Brazil, Bangladesh, Singapore, India, and Belize, you'll find out that the courts have played a very, very important role. If you look at numerous cases in India, like the one in Punjab, before you come to Justice Khanna's pronouncements in the state of Kerala versus India, where he came up and he said that if there is any kind of abrogation of fundamental rights of the Indian people, fundamental rights, Parliament cannot interfere, full stop. They cannot undo what the Constitution or what the people of India have decided to come up in unison. They cannot prolong life, they cannot take away life with just justification, and they cannot take away some kind of freedoms. That is number one. Number two, from the same case of social active litigation, I mean from the Kerala case, India came up with certain pronouncements which were done by Justice Bhagwati, when he said that locus standi is here now open. Standing is now open to anyone who is an Indian national wherever he is, on any matters that affect fundamental doctrine of the doctrine of basic structure. In that if you see government action or government agency or any other person acting on behalf of the government of India in interfering with, you don't necessarily need to stay. You can do the following things. Number one, you can take a rickshaw to the Supreme Court of India, or do what we call epistolary, write a letter to the Supreme Court of India, or go and petition the Supreme Court of India, or even walk in and whistle, whistling, telling the court or bringing to the attention of the court that something is wrong. And the courts will come up on their own motion and will stop that action and then give the pronouncements as to what is to follow. And Justice Khanna was very clear. And that's why my guru, Professor Upendra Bakshi, who is a well-known guru to myself, Dr. Ekuru Okot, and Willis Mutunga, Willie Mutunga, the former Chief Justice. I mean, we are students of Professor Upendra Bakshi. Bakshi came out now to develop what we call the social active litigation, which the British came up and borrowed it into public interest litigation, which is actually also part of the common law pronouncements here. And he said that where there's justiciability issues to be taken consideration of by the courts, they should be left to the courts, and that's what the courts in this country have done. You
know, interestingly, yesterday I heard Wakili Kibe. Wakili Kibe, on the other hand, argued that this wouldn't be, a role of the court, and that the court has ripped off Wanjiku of the opportunity to go and speak of what should be spoken by Wanjiku, and the fact that, this is more of a political process, all the BBI, change of constitution, and therefore the courts in their own wisdom should not have engaged themselves in making a ruling of this nature. I got confused somewhere in between, because then we get to ask ourselves, it's all right, it could be a political process, but Kenyans have lost faith, in our politicians and the structures that we have politically in the country. And so where do we cut the line when petitioners proceed to court to argue to court that this is something that we feel, has a problem, and therefore we need to address it, in an amicable way, and therefore we term the courts to be the best body to proceed and address this. At what point then do we get this line? It is a political process and therefore should be dealt with by politicians, or should proceed to the courts?
Well, thank you very much. Yeah. Yes, indeed, the review of the constitution is largely a political process, and it is a political process that pits politicians. It brings politicians together, separates them, brings different opinions and different thinking from politicians, and is an opportunity for the politicians now to engage Wanjiku and the common man, so that they can be able to come up with the kind of a constitution that they would desire to have for their country. But again, when the politicians are getting involved in this, and when they are doing this process of changing the constitution, they are also bound by certain rules and procedures. And now that is where the legalese comes in. That is where the issue of legal requirements come in. That is now where the judges come in. That is where the court comes in. That's where the system of justice is involved. Because all of you must change the constitution politically, but then as you do it, as you engage in it, you must then observe certain rules. And these rules and procedures are also set by the same constitution. And when any one of you goes against those rules and the procedures, what happens? The courts come in and tell you, come on, follow this route, or you used the wrong route. And in this case, for example, what was being said is that the president can't be the president and be a Wanjiku. Either you are one of them. Either you are the one.
The courts at some point accepted that it was a little bit too hard to deliberate on that.
No, I mean, they had arguments. And then it's good to follow what the court said, because a court sometimes will argue to the extent you think that is a right argument, but then they will also bring this other argument. I get it. And by the time they are in conclusion, they are concluding that even though you still enjoy civil rights as a president, even though you still have your fundamental and constitutional rights as a Kenyan and a citizen, but still then, you now find these other argument that comes on board, that we have provided leeway for you when you are the head of state, and when there is a government, you have your own kind of a leeway that you can use to have the constitution reviewed. And then the courts have now to come and interpret and say, when we allowed the public to also have a say in how to review a constitution, or when the constitution actually gave the public leeway to do so, this is what was expected. And indeed what was expected is that should there be a time when the government is a bit hesitant to listen to the people, Should there be a time when government turns rogue? Should there be a time that people feel like they are being misruled by the government? Then they can come up together, sign or take some signatures and agree that they are going to change the way they are governed. These are the people. And it must emanate from the people. And really, that is what the courts are saying. Even though you enjoy the civil rights, even though you have fundamental and constitutional rights, you still then cannot be that person who is also feeling oppressed and is feeling like the constitution is not working for them. That is only left for the public and for the masses. And it must be initiated from the masses, not by a gazetted committee funded by the state with the thinking of the state. I mean, and so when the president says, and I believe the president sincerely says that he has good things for Kenyans in the BBI, and indeed I believe that the president was very sincere. But this is where now we blame the Kihara Kariuki, the AG. In fact, Professor Wajakoya has said it very well. Professor Kihara Kariuki, by now, not even in America, not even in Europe, by now, even if he considers himself properly civilized as a Kenyan in terms of being a proper, civilized Kenyan, by now he ought to have resigned.
Okay.
I don't know what he's sitting in the office doing. He ought to have resigned, or the president ought to have sacked him. Because he misled the president. President had very good intentions. President wanted to review the constitution for the benefit of Kenyans. President wanted to have a number of things done right going forward. But he was misled on how to do it. Imagine the president had the opportunity to go to the parliament and have the parliament initiate this process. And we have not seen a time when the parliament has let down the president in his quest to come up with certain legislation. The parliament has been very supportive of the executive. So even in this case, I believe they ought to have been, or they would have been, very supportive. But can you imagine, the Kihara Kariuki, the AG, takes the president through a wild goose chase. And at the end of the day, it embarrasses His Excellency, the President. So for this reason, I believe he should resign. And any attempt to appeal this process is basically an attempt to save his face.
All right, save his face.
But how long can he do that?
Exercise in futility, you think?
Of course it is an exercise in futility. How long can he save his face? I mean, the Supreme Court cannot go against these other two courts. I mean, these are 10 judges. They are 7 plus 5. These are 12 judges. And if you have to look at the ones who have been who have...
the numbers that have approved seven versus...
I mean, it's only two judges. And only on very few issues, by the way.
Yes.
Only two judges.
That have gone against.
Who have gone against this, the High Court ruling. Yeah. And even when they have gone against that High Court ruling, it's not on all the issues. It's only a few issues. Are you getting?
Yeah.
Only a few issues. Otherwise, they agree with the High Court that everything was, most of the things were done illegally, irregularly, and unconstitutionally. So there's just no way you can expect the Supreme Court to go any other way. Even if the president of the Supreme Court has been appointed recently and looks friendly, she can't tie herself. She can't put a nail on her coffin.
Oh, yeah.
She can't kill herself.
All right.
She will have to do the right thing.
Professor, do you agree with that? That it would be an exercise in futility for the Attorney General, who's already put up a fight, to proceed and challenge these at the level of the Supreme Court. Of course, I repeat, the key things that he seeks to base his argument on: applicability of the basic structure doctrine, popular initiative threshold, and presidential immunity. That
in itself is really not possible, given the fact that these pronouncements that were done by the Court of Appeal were not their own judges doing. These pronouncements had precedents and authorities and history and cases that have cases similar to this that have happened elsewhere that were brought into the reality of what was happening. There was no judicial activism here, because judicial activism had already been done in countries like India, where the judges came up to uphold the Constitution. Therefore, as the Speaker for Nyeri County Assembly said, if the process was flawed right from the beginning, where a few men and women were handpicked without the approval of Parliament, and gazetted, and to chart the way for Kenyans, and budget allocated to these people, an illegal process that was struck out by the High Court. Justice Gogi, I think, pronouncement were the best I have ever read.
Okay.
And now you have the same Attorney General now coming up and saying, I will go in. If Raila Odinga has said is no longer interested, he will abide by the verdict.
Yes.
The president has come up and said, Kenyans have decided. And Uhuru Kenyatta is one of the best presidents in the world because he abides by the law. Remember when he was elected president, he had still to go to Hague to clear his name. Remember when he was vilified, when there was an election petition, he accepted the results and he went up. And now he has come up and he said, well, I accept the verdict of the Court of Appeal. And he appoints those judges to the approval of a parliament. And Raila Odinga has also said that. And now the Attorney General is coming up and talking about applicability, popular initiative, and presidential immunity. Does he think that we never went to law school?
All right.
Probably some of us have more degrees in very recognized universities in the world that have gone through all this. He should actually seek judicial opinion of lawyers like ourselves, or go to India and get lawyers to advise him. Otherwise, that exercise, it has two outcomes. If it goes to the Supreme Court, first, it is suspect.
Okay.
How is it going to go there? Is it going to be invalidated again? Kenyans should read. Kenyans are the best human beings, and that's why I'm asking them to vote for me. They will read between the lines in case there will be a sinister move. What the Attorney General ought to do today is to resign, and those people at the Attorney General have been working and eating and dining with him during a tangible kind of communitarianism.
As well.
To resign and cause whatever they have to be intangible. Thank you.
All right.
There's something that Right Honorable Raila Odinga said, that he is going to respect the outcome of the court, and that he will not appeal to the Supreme Court. But then he also added that reggae must go on. I hope you noted that.
Yes, I did.
What does that tell you? When he says that reggae must go on, you know, you have to interrogate these pronouncements by politicians. That clearly tells you that reggae is not BBI, and BBI is not reggae.
Okay.
And reggae was never BBI.
Okay.
And that tells you that reggae was always about Raila Odinga's presidency. And that is why immediately when this pronouncement is done by the judges, he goes ahead to say, now, BBI behind me now, let me focus on my presidency to save time. Now, reggae was about Raila's presidency. And I think that is where BBI was not gaining much attraction, especially with Mount Kenya region. Because Mount Kenya region, somehow people have become pretty enlightened. They are now able to read in between the lines, as the professor says. People are able now to read what is not being said. And people don't just buy what you're telling them anymore. You don't just tell people that you don't want them to believe you. They interrogate. And sometimes they interrogate, but they don't tell you. They interrogate, laugh in their hearts, keep quiet, and move on with their life. And wait for you to burn your fingers. Because people have become, people have gone through many cycles of political deceits, political narratives, and blah, blah. And for that reason, now people have come to know that these politicians, we don't always have to take what they are telling us.
But I mean, probably reggae goes on at the level of parliament, as of course has been.
Now, sorry, I did not get you clearly. But
at the level of parliament, and I mean, making these amendments in parliament or the National Assembly.
No, I'll come to that. Yes. But then I wanted to say that first, reggae is not about BBI. Reggae was always about Raila's presidency.
Okay.
Now, what has Paul Mwangi said? I listened to him in another interview where he said that, even if we are not going to the Supreme Court, we expect that somehow someone will go to Supreme Court. By that time, the Attorney General had not pronounced himself. But it's clear that as much as Raila is now engaging on his presidential campaign, another person in the mix is doing the appeal for them and for him. Are you getting? And not to win, but to save face and to keep Kenyans engaged.
Okay.
Particularly to keep those ones who are so engrossed onto the BBI, to keep them hopeful. Okay. To make sure that they don't lose hope completely. Now, there are a few issues that politicians have talked about going to the parliament. Particularly the COG has talked about a few issues that need to be looked at, and they have said they will pursue them through other means. And I dare say, the COG, I'm a member of the devolution community, I know when I see Professor Kiraito Murungi, who is a very, very senior lawyer in this country and a very good legal mind, they also need to be honest with themselves. And they also need to be honest with Kenyans, my COG fellas. Don't tell Kenyans that you want to go to pursue BBI on health matters, on tax breaks. I mean, sorry, on health issues, higher education loan board. This is an administrative thing that can be done and should be done by health itself. Higher education loan board. They just need to come up with the regulations. They need to forward them to the treasury, and the COG does not even come in anywhere. This is not an issue that we should even be disturbing our minds with. It's not an issue that we still need to be bringing to Kenyans to entertain their thoughts. We just need to come up with this arrangement. I also want to dare even those other members of parliament who are not either in support of BBI or even those who are in support of BBI. Let's parliamentarians just go to the parliament, just come up with a motion or even come up with a bill that, or even come up with I mean, if the government is not coming up with the regulations, then as members of parliament, you can initiate that process so that you can do a motion to urge the government to do that. The issue of the tax break again is an administrative matter. It is an issue that you put in the finance bill. As they're doing the finance bill, and I know they're actively now on it, this is something that they just need to have it inserted and then voted in by the parliament, and that is done.
Fair enough. Yes.
So the only thing, in fact, also the issue of the shareable revenue, 15% is what is minimum, but 35% can be achieved also, even more than that, even 50%. So what I think they can, or they should be talking about probably is just the issue of the ward fund, the equalization fund, addition of 10 years, and maybe the county assemblies fund. Those are the things that maybe they can be able to pursue through other legislative means.
Okay.
Yeah.
All right. So thank you so much, gentlemen. And because you have not declared your next move politically, I think I'll allow Professor Wajakoya 30 seconds or thereabout to speak to his people.
Thank you very much for inviting me today. And I'm also very grateful that I've met my friend after many years. I think now we'll go to Nyeri, Kroini, and I hope he's vying. Let me announce it for him.
Is he?
He's vying, but I don't know whether I'm right.
You tell us.
But he could be vying, and I wouldn't mind coming to talk to the people of Nyeri. I'm not here to campaign for myself, but what I want to tell Kenyans is, this is high time you came out and realized that political system here has been fooling you for a very long time. Whenever it comes to political season, the politicians come up with different colors, and it's your time. It's your time now to disengage and find out what is the right path for you to follow. Follow what is in your heart. Choose the leaders that will work with you. Do not choose leaders that will come in and do the same thing, recycling themselves and recycling the economy and recycling the people of Kenya and recycling everything that you have with all formats and formulas that are coming out. And thank you very much.
Thank you so much. We close.
Yeah, definitely. That. As you close, I also want to wish Professor Wajakoya as well. I'm happy to have also met him after some time, and I see he is growing younger and more brilliant. And I believe that he will be able to marshal the support he requires. Professor, keep on.
Thank you.
Right.
And we need bold and courageous Kenyans who can bring themselves out and face the monster.
Thank you.
I mean, we have to be men of ambition.